Canada's current privacy law, the Personal Information Protection in Electronic Documents, has a provision that has seldom been used until recently that allows the Privacy Commissioner to make your privacy decisions for you. In this episode, I'm going to talk about what it is, how it works, and my concerns about how it can take away individual autonomy, which is at the heart of privacy. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a very high-level overview of a pretty complicated and nuanced subject. Any opinions expressed are mine alone and should not be attributed to my firm or any of its clients. Privacy means different things to different people. To me, after practicing in this field for more than 20 years, privacy is fundamentally about individual autonomy and dignity. Individuals should have control over what information they share with others. They should control what they share and who they share it with. If they actually control their own information, they should be fully in control of their personal information and all the decision-making around that. When you talk about an invasion of someone's privacy, it's generally because that choice has been taken from them, and their personal information has been used or invaded without their full consent. That is an insult to the person's individual dignity and autonomy. This control is central to your personhood and your individual dignity as a human being. Conceptually, this came up in a relatively recent case from the Supreme Court of Canada called the Sherman Estate and Donovan. This case was about whether the media could get access to a probate court file, which raises freedom of the press and open courts issues. The court had to consider where privacy comes into play, and that, they found, is very closely connected to individual dignity. If you have to include personal information in a court filing, and you don't have any choice in who gets to access the public file, the rules of court and the rules of our judicial system are effectively removing the choice about the disclosure of personal information. So this case was fundamentally about taking away someone's choice about what to share and with whom, balanced against other very important public interests. The court said privacy is a public interest that engages individual dignity, which must be considered in the analysis. On this point, the court had some very important things to say. They said, there is value in leaving individuals free to restrict when, how, and to what extent highly sensitive information about them is communicated to others in the public sphere, because choosing how we present ourselves in public preserves our moral autonomy and dignity as individuals. The court then went on and quoted from a much earlier decision which noted, quote, the personal anguish and loss of dignity that may result from having embarrassing details of one's private life printed in the newspapers. The court later noted, quote, dignity used in this context is a social concept that involves presenting core aspects of oneself to others in a considered and controlled manner. Dignity is eroded where individuals lose control over this core identity-giving information about themselves because a highly sensitive aspect of who they are that they did not consciously decide to share is now available to others and may shape how they are seen in public. So here's the thing. PIPA has a provision that's generally designed to create guardrails. It sounds very sensible on first glance, but really it could be used and has recently been used by the Privacy Commissioner to take away that choice and autonomy. What it says is that, quote, an organization may collect user-disclosed personal information only for purposes that a reasonable person would consider are appropriate in the circumstances. This is a baseline and can block things regardless of whether the person consents to the collection, use, or disclosure of their personal information in the particular circumstances. You may think that it's a reasonable or appropriate purpose, but if a reasonable person, i.e. the Privacy Commissioner, doesn't think it's appropriate in the circumstances, then it's simply a no-go. It makes sense to have guardrails for extreme cases that are beyond the pale, but there have been very few cases where voluntary, knowledgeable, fully informed consent has failed so badly that we would really need to resort to triggering Section 5, Sub 3. At the same time, there's been considerable discussion in the privacy community about whether consent is still up to the task. After all, nobody reads privacy policies, and the technology we interact with is increasingly complicated. Consumers, they say, don't understand what they're agreeing to. I have some thoughts about that. At least in Canada, consent is not based on privacy policies. Section 6.1, which was added to PIPA in 2015, clearly sets out what is required for consent to be valid. The consent of an individual is only valid if it is reasonable to expect that an individual to whom the organization's activities are directed would understand the nature, purpose, and consequences of the collection, use, or disclosure of the personal information to which they are consenting. If the person didn't read the privacy policy, then the consent is invalid. If you're relying on the privacy policy for this reason, then you're doing it wrong. The organization has to find another way to communicate this to them. If the person doesn't understand the nature, purpose, and consequences, then the organization didn't do a good enough job of communicating this to the individual. But in my mind, just because some people make ill-informed choices or choose to be reckless doesn't mean that my ability to make well-informed choices and ones that fit within my privacy comfort zone should be taken away from me. For a long time, this provision was hardly used. Privacy commissioners appeared to be very hesitant to wade into scrutinizing activities through this lens. That was then, but in more recent years, the Privacy Commissioner has been less hesitant about using this section. In May 2018, Commissioner Terrien produced guidance on what are considered inappropriate data practices, or so-called NoGo Zones. I'll discuss this and his framework and a couple examples of how it's been applied from published findings. I'll also share some of my own thoughts about how this can be offensive to individual choice and autonomy, which is at the core of privacy. In this guidance document, the Commissioner essentially creates 6 no-go zones. Some of these seem to me to be superfluous or in addition to other laws that address the issue. The first is collection, use, or disclosure that's otherwise unlawful. For this, the OPC gives the example of creating a bad tenant database, which is already unlawful under consumer reporting legislation. I'm not sure that privacy laws needed to come to the rescue here, but it does make sense that if the legislature has said it's unlawful, then it's de facto unreasonable under privacy laws. Number 2 is profiling or categorization that leads to unfair, unethical, or discriminatory treatment contrary to human rights laws. So it's already unlawful to discriminate in Canada on the basis of the grounds set out in human rights laws. Using personal information to do so is no more or no less unlawful under those laws. But it also still makes sense that if the legislature has said it's unlawful, then it's de facto unreasonable under privacy laws. The third is the collection, use, or disclosure for purposes that are known or likely to cause significant harm to the individual. In this context, the OPC takes the description of privacy harms from the data breach disclosure rules. While none of this is a good thing on its own, we are otherwise permitted to voluntarily do things that create risk of harm to ourselves. It's certainly not a good thing for somebody to create a service designed to do these things, but if it's only a risk and the person has knowingly and voluntarily agreed to it, I think their informed choice should prevail. The fourth is publishing personal information with the intended purpose of charging individuals for its removal. This relates to the situation in the Globe 24H case, where a person in Romania downloaded a bunch of Canadian court and tribunal records. They then put them online for the sole purpose of getting people to pay him to take it down. Now, I'm okay with using Section 5 sub 3 for this, though I note that all of this was done without the knowledge or consent of any of the individuals concerned, so it was already offside the legislation. The fifth is requiring passwords to social media accounts for the purpose of employee screening. This too would likely already be offside the legislation, since you really can't say that consent is freely given in those circumstances. Also, in the employment context, one can only deem consent for reasonable purposes, so this also crosses over with Section 5 sub 3. Now, the sixth and final one is surveillance by an organization through audio or video functionality of the individual's own device. And this comes from a case where a computer rental company used spyware to activate the cameras and microphones on computers that they owned but had rented out to individuals. This is a case where this would not have been done with adequate notice and consent from the affected individuals, so would have already been offside on that basis. It might have even been a criminal offense. I'm not sure that Section 5 sub 3 needs to come to the rescue here. Two recent cases immediately come to mind where the Privacy Commissioner found that an organization had violated Section 5 sub 3 and was offside the legislation right out of the gate. The first is the investigation of Clearview AI, and the second is the investigation of the Tim Hortons mobile app. In the Clearview AI case, the OPC investigated a company that had scraped billions of photos of people off social media sites and put them in a facial recognition database, mainly for use by law enforcement. But they'd also demoed the product to private businesses. The OPC found that they would have needed the consent of the affected individuals to do this, and they did not get it. So bingo, no consent makes them offside PIPA, and that should have been enough. But the OPC went further and concluded their purposes were those that a reasonable person would find to be inappropriate. In the end, they didn't need to go there to make their obvious findings that Clearview AI was offside Canadian privacy laws when consent was there and did the job. The second case is one I find a bit more problematic, and this is the use of location tracking software as part of the Tim Hortons mobile app. In a nutshell, users of the Tim Hortons mobile app were not adequately made aware that the app was tracking people's locations, like in a very granular way, like noting when you're at home, noting when you're out and about, and when you're near a Tim Hortons location. When the app was first launched in 2017, it used the location services on your mobile device only to locate the nearest Tim Hortons restaurant. Seems reasonable. The OPC noted at the time user location even was not recorded. A later version significantly increased the location information that was collected and retained. The idea was that it could tell how long it would take you to go to the store and pick up your order when you placed an order using the app. The reality is that way too much information was collected and the restaurant really didn't have any purpose for it. It just hoovered up the data and it kept all the data for one full year. The OPC found that this was inappropriate and violated Section 5 sub 3 of PIPA. They also found that they didn't get adequate consent for the collection and use of this detailed location information. Again, lack of consent could have dealt with it, but saying this sort of location tracking is illegitimate out of the gate, they're actually foreclosing the possibility that people could make intelligent, informed decisions about this sort of thing. Think of all the clever things that could be done with detailed location information, as long as you had clearly informed consent. This sort of information could provide a lot of value to the consumer and to the organization on a clearly opt-in basis. So imagine this sort of scenario. All the independent coffee shops in a city get together and they launch an app. They promote it to their collective customer base. It permits remote placing of orders, maybe even delivery. You can find your closest independent coffee shop and filter it for the types of coffee drinks you like, what's available, whether they serve food, do they have outlets for your laptop, do they have free Wi-Fi, and maybe as an added bonus, if it detects that you're going into one of those huge chain coffee shops, it'll ping you with the location of the nearest independent coffee shop and offer you a one-time discount if you go there instead. The app could also keep track of your preferences and make recommendations based on your drinking and dining habits. Hey, add a social layer. This coffee shop you're nearby in a new city is one of your friend's favorites. I would install that app. They'd, of course, have to do a good job of managing the data, but I would totally install an app like that. Any company reading the reported findings about the Tim Hortons app, however, would assume that all of this is in a no-go zone and too risky to contemplate. And that's too bad. A diligent organization that knew what it was doing and was focused on fully informed consent from users should be able to do that. But now we have this finding that leads everyone to assume that location services are toxic. In the end, I'm glad that Section 5 sub 3 of PIPA is there to provide the guardrails to address those outlying cases where the principles of PIPA, like consent, can't keep up. But I think it needs to be reserved for those very few cases where the practice is otherwise unlawful or the activity is inherently harmful. If the organization is able to get actual, freely given, informed, and voluntary consent, people should be able to make their own decisions, make those decisions for themselves, and not have the privacy commissioner, who clearly has his own understanding of privacy and reasonableness, make those decisions for you. Even worse is when the right to make a decision is taken away from you. I hope this discussion has been interesting and perhaps even useful. I try to put out a new video each week or so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics you'd like to see covered. And of course, feel free to share this with anyone you think who may be interested in hearing about developments in Canadian tech and privacy law. Thanks for tuning in.